Hello and welcome to another episode of eDiscovery Chicks, the podcast about all things eDiscovery and legal tech. Hosted by two gals who are really glad that neither of our guests got hit by a falling iguana today. Anyways, we're your hosts. That's Bree.
That's Angie. Super random thoughts from the eDiscovery Chicks. But today we're talking about AI literacy, and we have two very special guests. So before we get started any further, I feel like, Angie, we need to do an intro of our two favorite Ralphs.
Yes, our absolute favorite Ralphs, and welcome back to the pod, both of you. So our guests today are Ralph Losey and the Honorable Ralph Artigliere. Ralph Losey is a longtime legal tech and eDiscovery voice, a retired lawyer and arbitrator, and the writer behind the eDiscovery team blog, which I cannot recommend highly enough, y'all. It is absolutely amazing. On the blog, he publishes deep dives into AI, eDiscovery, and more recently, quantum computing. He has also spent decades working at the intersection of law and technology. I'm talking litigation, arbitration, information technology disputes. And in recent years, he has focused heavily on generative AI. If you want to go deeper, I cannot recommend his blog, eDiscoveryteam.com, highly enough. He also has prompt engineering courses designed for legal pros, beginner through advanced, plus a free technology-assisted review, or TAR, for those in the know, course. And our other guest is the Honorable Ralph Artigliere, who is a retired Florida circuit judge from the 10th Judicial Circuit and a trial lawyer turned judge who spent his career obsessed with one thing: credibility, how to build it, how to lose it, and how to avoid detonating it with shortcuts. Before the bench, he tried cases in private practice, including professional negligence, med mal, and product liability. As a judge, he served across divisions and became a national teacher on professionalism, evidence, ethics, technology, and eDiscovery. He's also been closely involved in the evolution of Florida's eDiscovery practice and is a fellow of the American College of Trial Lawyers. So without further ado, welcome, Ralph. Welcome, Honorable Ralph. We are so thrilled to have you back on the pod.
Thanks for having me. I appreciate it. And I always love to be here with my friend Ralph.
Equally thrilled to be here with the chicks. It's quite an honor.
The Ralphs and the chicks.
We love having you guys. Thank you so much for taking the time to be here. And honestly, after that introduction, I feel like I should just kick back with, like, I don't know, a cocktail, put my feet up, and let you guys take it away. But first of all, Angie, you said something about falling iguanas. Please explain yourself.
Yeah. You know what? I'm going to actually punt that one to the Ralphs here. So this is a Florida specific problem. Is that right?
It is. We had a very cold spell about 6 weeks ago or so. It got down to below freezing. Hasn't happened since 1938. And since that time, Florida has been invaded by iguanas from outside of the state all over. And turns out in cold weather like that, they just fall down.
Like out of trees.
In South Florida, they're in everybody's backyard. They're kind of a nuisance as they make leave deposits that are unwanted everywhere, stuff like that. So for some reason, Angie really thinks that's hilarious. Falling iguana.
Well, I'll tell you the reason why we think it's hilarious is because we were told this by a friend of ours, Emily, who you guys might know her, Markowitz, who lives in Miami. But she was like, the worst thing is when you throw one away and you don't realize it comes back to life again. I'm like, what? Can you imagine?
They're not dead.
You're like,
Yeah,
this is why Jurassic Park happened. Is that right there?
I mean, I thought Texas was crazy, but this is a whole another level.
Oh my God. Well, I'm hailing right now from colder climes up here in Seattle, but we don't have any iguanas. So far, nothing is falling out of the trees on me, which is nice.
We're excited today to get the scoop on AI from both of you. And you both offer such a great perspective, and both from a judicial perspective, but also Ralph Losey. I know that you're heavily invested with your blog and your educational offerings. So thank you so much for being here. Angie, do you want to get us started off with something? Am I hallucinating those iguanas, or are they real?
You're right. We are going to move into hallucinations and sanctions and the chilling effect of those. But before we do that, a quick disclaimer for y'all. The thoughts and opinions shared in this episode are ours alone and don't represent the views of our employers or associates. This podcast is available solely for educational purposes to provide general information about eDiscovery principles and not to provide legal advice to any specific situation. Anything we say here today is not a substitute for legal advice from a lawyer you've retained and who has agreed to represent you. Okay, time to talk about the thing that launched 1,000 law firm memos. So, Honorable Ralph, you wrote AI Hallucinations, Sanctions, and Context in JD Supra, and that was published on January 9th, 2026, for anybody who wants to go and find that. And you basically called out the profession for reading the scariest headlines and skipping the part where the context exists. So, I want to surface that tension. What's the real misconduct? What's reasonable verification when it comes to AI? And what's the danger of everybody panicking and just banning AI or not using it?
Sure. Well, this it sort of comes about because when hallucinations first started, and that was with the Mata versus Avianca case, we all kind of thought that that was an aberration, and people would see that these things cause problems, and that they would not submit court documents that have hallucination in them. Well, here we are years later, and the number of hallucinations in cases, it seems to be on the increase rather than going away. It's a real problem, but it's not the type of problem that people are perceiving it to be. For example, there's a guy named Damien Charlatan who he has a website where he keeps track of all of the hallucinations, and he's got like over 1,000 hallucination cases now. It might be 1,100 by now, and it increases every week. That's international, for one thing, so it's more than just the United States. And the majority of those are pro se parties, not even attorneys. So when you actually look at it, the problem is bad, but it's not as bad as it looks. The knee-jerk reaction from, unfortunately, the courts and unfortunately law firms is to think that this is something that's going to prevent lawyers from easily or safely using AI. And that's a problem. It's a problem, first of all, because a lot of these cases are not really the AI that caused the problem. There's the supervision or the lack of verification. And we'll talk about verification later. But the other thing is, we've been having problems with people submitting information that's not correct forever before we ever had AI. So there's no reason to think that this is some kind of existential problem. But when a law firm bans the use of AI, it doesn't go away because their young lawyers are going to want to use it because it's too good and it's too powerful. So just a good sort of contextual example of this is the Dunn case in Alabama, Johnson v. Dunn. It was a case where two supervising lawyers got a memo from a younger lawyer who was also a partner. He wasn't a real young lawyer, and they had worked together a number of times before. And the firm had a policy, no using AI. But this lawyer used AI, and the hallucinations got in the case. So there are 3 lawyers who get sanctioned. The lawyer who used the AI, and he said, mea culpa, I did it. You're going to sanction me, that's fine. But the judge also sanctioned the 2 supervising lawyers, and the sanctions were very tough. The lawyers were reported to the bar. They had to report the case to every judge that had a case with them in front of them. They had to do so many things. They were like career-changing sanctions. The fact of the matter is, banning the AI didn't work for the law firm, so that's not going to work. And not understanding that this was just a lack of supervision and a lack of checking is really a problem. So I think that we all need to take a breath here and look at this for what it really is, and then address it. And the way to address it is through education, not through banning the AI.
Yeah, I mean, when I was a baby lawyer, I think it was my greatest fear that I would submit something untrue to a court. And that was this was before the days of AI, the days of yore, right? And I don't think that's changed with the advent of AI. That fear remains the same. It's just in a different context.
Yeah, but just look at it this way: what's really worse, somebody who intentionally misleads the court by misstating something, which happens all the time, unfortunately. They say this case stands for this, or they cite a case that doesn't really meet it. And I have to deal with that as a judge. I think that's worse than somebody that negligently does it. Negligence is wrong, but it's not intentionally misleading the court. So when you get these almost draconian sanctions from judges, that's a potential problem. Or orders that say you can't use AI in my court, which is happening.
I'm curious. I know that you've talked a lot about verification, Judge, and Ralph Losey. And I'm curious in terms of education, where do you think the burden lies? Does it lie solely with the attorneys? Does it lie with their staff? Does it lie with IT professionals, software companies? Like, where does that burden lie in terms of you must be educated, you must follow this protocol, et cetera?
I think the burden is on the law firms and the people who are supervising lawyers who are using these things. And they have to make sure that there's a systematic way that you go about this. It's just like anything else. When Ralph and I were coming up, we would be horrified if an associate did work for us and didn't understand that they needed to shepherdize the cases that they put in there and made sure they're the most recent cases, right? So if they didn't get properly taught, we would supervise them in a way that they would understand that before it becomes a danger. And we do that by, when they're first working for us, checking their work more carefully than they did before. So this is no different than anything else. I mean, AI is the same way. You have to check everything. Everything has to be checked, just like you would shepherdize your cases, just like you would read the case itself and make sure it says what you're putting in your brief. That's true of everything. And AI is just another layer here. And as Ralph, I'll let him talk because he knows that AI can't take responsibility. So somebody does, right, Ralph?
Well, that's right. I mean, I think, we'll look back on this point in time with amusement, the future generations, and say they tried to ban AI. I mean, on one level, it's funny. It reminds me of when I was in a meeting once with a couple other attorneys from a large firm I was with. It was a top 10 largest bank in the world. And we were talking to them about eDiscovery and the problems with the preserving email and stuff. And the general counsel, older man, said, "Well, I got the solution. I am going to, starting tomorrow, I'm going to ban everybody in the legal department from using email." And
Oh my God.
lawyers. And and we're all just trying to suppress, laughing out loud at the foolishness of it. And of course, that never happened. So, I mean, I think we'll look back at it on that way. It will come, and we have to adapt. I agree with everything the Honorable Ralph. I don't know where that makes me, but the other Ralph uh, is that under the rules of professional conduct, it lies on the shoulders of the attorney and not using the unfortunate language I totally disagree with that you find in the rules, the non-lawyers in a law firm. But the responsibility to supervise is critical, and that lies on the attorneys, people that are in the bar, which I am retiring from or trying to. And so, but they have a responsibility to teach, and it's their license on the line, it's their reputation. But so too does the larger legal profession community, particularly law schools. And law schools need to adapt and get with it. And so, everybody came out of law school in my day and they knew how to shepherdize. It wasn't something you had to teach them. Maybe you got out a little bit before I did, Judge, but everybody knew that. And now people get out of law school and that, they may be told, "Oh, you can't use AI. I want to see your work," and all of that. So the schools need to adapt. That takes time. It took a long time to get schools to recognize eDiscovery as a legitimate subject. There are a few exceptions, like my alma mater at the University of Florida, and the law schools need to own up and get with the program.
Yeah, I completely agree. But I want to return to the idea that I mean, maybe this is subtext in our conversation, or maybe we're just like naming the thing out loud, but verification isn't rocket science. It's professional competence. And so, question for either of the two of you, why do you think lawyers are still failing at a bar that A has been around forever and B seems pretty reasonable to manage? Is it time pressure, lack of training, or incentives that reward speed over accuracy, or maybe something else entirely?
I think it's a combination of all of that because, as you know, AI a lot of times produces very seductive material. I mean, it sounds good. It sounds like it's really right about what it's saying. So you just can't fall into that trap. But I also think it's because lawyers are just so dang busy these days with, responding to. I mean, we used to have an inbox, stack of paper, and and if the inbox looked too high, you could see that. I mean, the equivalent today is looking at your email and seeing all of these new emails that you have to respond to, and 5 of them are from your most important clients, so they do have time pressures that we didn't have before. So they're looking for the easy button. In addition to that, the industries that are pushing AI tools, including the big players, are pushing tools that are easy button tools. In other words, it'll draft for you, it'll research for you, it'll do all these different things. And lawyers are sort of relying on them, which is bad. I mean, I think that that's not the way to use AI. It's something that should be used as a co-intelligence rather than doing the work for you for a lot of reasons. And there's another side problem with that. I mean, Ralph mentioned law school and college. People using AI in law school are losing some of the intuitive and the human skills of reasoning and legal reasoning that they would have otherwise gotten if they did the work instead of having the AI do the work for them. And the same thing goes for young lawyers. So, we have to be careful about how these things are used in a number of ways. You're exactly right. Verification is non-negotiable, and it's something that every lawyer should know already to do.
Yeah, if I can jump in, I just recently wrote this article on cross-examining your AI. I mean,
Oh,
any
we're coming
lawyer
to that.
who's a litigator, we should be the best in the world at using AI. Once we get past the hype of, oh, it's so great, it's not so great. It needs to be cross-examined, but we're trained to do that. And when you do that, then it can shine. So, I'd say we can verify. It's what we do anyway as a good lawyer. We verify witness statements. So I think we'll overcome this pretty quickly.
I think that you guys are talking about shepherdizing, and first of all the hairs in the back of my neck stood up. But that's neither here. But I remember back in those days that it was kind of like doing a logic, equation when you're in college. It's like there's a perfect way for you to cite this, citation perfectly so that it is shepherdized. And as a paralegal, I would get involved with that a lot. It was very, very black and white. And I think with AI, it's a little bit more of a gray area because we don't really know, to your point, Ralph Losey, how to cross-examine our AI. Like, what does that mean? And how do we go about doing that? And is there a kind of standard way of that cross-examination process? And I mean, probably at this point in time, the answer is no, and maybe we'll get there. But I think that in my perspective, that's part of the holdup here is kind of like, yeah, I mean, it sounds good, but I don't really know how to put that into practice. And I also don't know how to train my paralegals or whoever else is doing some of this repetitive, administrative work for me. Like, I don't know how to put this into a repeatable process. I don't know if y'all have any thoughts about that, but just from like the staff perspective, and go ahead, Ralph Losey, I see you raising
Well,
your finger.
yeah, I mean, that's what I did at the last law firm is to set up standardized procedures on eDiscovery for, I guess, about 100 lawyers that specialized in it in my old firm. So I'm very familiar with this, and I'm telling you, it's not any more difficult than eDiscovery because we've already got training in cross-examination and how to talk to witnesses, just like we already had training in discovery. Um, I don't find it that difficult, and I'm writing about it, give very specific suggestions on what to do, and they can be passed along. They can be routinized, but it's going to require, just like eDiscovery did, it's going to require that you have at least one go-to guy in your law firm. A bigger law firm, there'll be teams of them. Maybe there'll be 100 of them, but it's somebody that really knows this stuff well, and they need to teach the others, and they need to find the routine that fits their firm. And so to just cluelessly think this isn't that important, that's a huge mistake. And we all saw that mistake in eDiscovery. I remember having people tell me, oh, just rely on a vendor. And, we love our vendors and they did know it, but honestly, you need to have an attorney in your firm or a paralegal or somebody in your firm that really knows this stuff and spends the time that it takes to learn it, because it's important. It is the future. You want to prepare for the future, then you need to learn AI. Not every attorney is going to do that, but there should at least be one or two. In the next generations, they will do it.
And let me say that I understand this problem with lawyers because I was one of those until I took Ralph's course as a beta tester and then understood the real depth of what you need to do, and require the AI to either cite or silence, and require the AI to check itself, and then you check no matter what at the end. Those were things that you don't intuitively understand about it. So Ralph's course was instrumental in getting me to do that.
Ralph Losey, I want to stay with you for a second because in your December 17th, 2025 article, Cross-Examine Your AI, you argue that AI should be treated like an expert witness you haven't deposed. It's impressive, it's confident. Like Honorable Ralph said, it produces these really seductive, velvety responses. But ultimately, it's really capable of being quite wrong. So, what do you think is the single most important behavioral change for lawyers? Or is it more of like a state of mind when you're interacting with AI?
It's not really going to be that difficult once they realize that it is a BSer. It will very reluctantly admit it doesn't know. And so you have to train it. And this is part of the engineering stuff. Train it to tell me you don't know, because it's training from the learning processes that it will answer. That's what people expect. They don't expect the AI to say, well, I really don't know, next question. And so you have to tell it that. And you have to do things like admit that this is something where there's uncertainties. You have to ask it to be self-critical. The best lawyers have always been self-critical. I remember a senior partner listening to him, and when he was all set to go, then he would encourage people, now, what's wrong with this plan here? Tell me, give me some, attack it. He would invite criticism. Have the AI criticize its own work, and then use another AI to criticize the AI's work. I mean, debating AIs is an amazing thing to watch, because they will find stuff that I'm not smart enough to pick up. But so when you get the AIs to coordinate their effort, to prompt and be the engineer that designs how this all works, then you'll find that these problems will be greatly diminished. Now, still at the end of the day, you got to read it. You got to make sure it's right. But, perfection is not possible in the law. It never has been. People have always made mistakes. But the gross errors that only an AI can make, like computers, if you really want to mess things up, have a computer do it. It will. But there are many tricks that we can do with AI, even with the AI we have today, which is still primitive. It's going to get smarter. And that's why it's difficult to teach prompt engineering that will be worth your spending the thousands of hours it takes to get deep on it. But there's some things that will remain. And one of them is have the models check each other's work.
Now, you mentioned that being self-critical or having the AI be self-critical is super powerful. Now, stick with me through this. I'm a Gemini, which means I've got two very competing different sides of my personality, one of which is fairly confident in myself, and the other which thinks I am woefully inadequate at most things. Does that make me an ideal AI user because I'm already well-versed in being self-critical?
Well, I recommend you use the Google Gemini model.
Oh, I should. The stars would align.
No, but being a perfectionist is a good thing. I can tell that's who you are. And you can get over critical paralysis by analysis. You've heard this. I mean, we used to always tell our associates that, and I know judges get so impatient, another motion to continue, and I don't blame them. There comes a time when you've got to make a decision and you got to go with it. You got to press the file button. But there are people like us, because I'm that way too, that kind of maybe go a little bit overboard, and you just got to train yourself up. This is a reasonable effort. This is proportional. That's the key word in eDiscovery, right? Proportionality in your efforts. No one, not even Judge Shinlin, she admitted this, it wanted perfection from defendants appearing. They just want reasonable efforts, and it's reasonable to do shepherdization, to make sure that your case actually exists. How could that not be something
It's
anybody
like
would do?
so
And that,
base level.
oh,
Honorable Ralph, this one's for you. So in Ralph Losey's article, he is pretty clear that, it sounded right isn't enough for verification. If you had to define the minimum acceptable verification standards for anything that might end up in a filing, what are the non-negotiables there?
Non-negotiable, you look up the case, you read the case, you check the quotation and make sure that if it's quoted, that that's exactly what it says in the case. That's the minimum. Then you should also make sure that the case is the most recent case and that it's in the correct jurisdiction, because
Oh my gosh.
unfortunately, I mean, I was on a beta test for an AI. The product was actually producing cases from a different jurisdiction. That sounded absolutely great, but they didn't have any good use in the jurisdiction they were in. You just have to do the basic work, just like you did when you were doing this analog. You have to make sure that it's right. I can tell you from the time that I was a lawyer and then on the bench, this happened time and time again, long before we had AI, where somebody would cite a case and I argue it like it was on all fours and the greatest thing since sliced bread. And when you actually went to the case and looked at it, it didn't really say that, or unfortunately in the dissent. There are just so many ways that AI can pick up on things and put them in the case, put them in your brief that would be wrong. So you just have to just do the legwork and get that done. The other thing that you have to be careful about, this is a lot of these hallucination cases have citations for things that are actually, everybody knows what the law is. There's routine things. Okay, they might just be a precursor to the main event of what you're arguing about in the brief, and they put in citations that are wrong. Somebody checks those citations and then calls you out for having these hallucinated citations, and there was no reason to have that in there. I think both Westlaw and Lexis now have products where you can check citations, so you can just run your brief through them and they'll check the citations for you. I just think it's just read the damn case. I mean, just get it in front of you and read it.
It ain't
That's
that
all.
hard, people.
No, it's not that hard. It isn't.
Okay, so we've covered hallucinations like they're, something of a villain, something to be avoided. But maybe the bigger villain here might be AI's really beautiful writing, because, these platforms can make weak facts sound strong, and that's an advocacy problem, not necessarily a tech problem. So, Honorable Ralph, in your JD Super piece from January 20th of 2026 titled Effective Advocacy 101 in the Age of eDiscovery and AI, you basically, give us a warning shot. Try the case you have and don't let the tool launder the record and put a patina on it that doesn't really exist. And Ralph Losey, I mean, your work on verification and supervision is the practical side of that. So I want to turn now to a series of questions about how AI changes advocacy, how credibility can collapse, and what courts do when pro se parties start showing up with AI written filings. And Honorable Ralph, I'm going to go to you first. In your article, Effective Advocacy 101 in the Age of eDiscovery and AI, you say that the fundamentals of advocacy really haven't changed, even though our information environment has. What do you think is the AI era version of try the case you have? Is it anchor everything to the record, or stop letting AI reformat your weak evidence in strong language? What is that?
This is a really interesting thing, because when lawyers are handling a matter, the way to win that case is to find the path that you have the most strength in and take that path, and not to overstate anything in the case. And that, as a lawyer, that was my mantra. I mean, I wanted to find a theme that my witnesses and my evidence would absolutely support, so that I would not be in front of a jury and have the jury, and then it's the same thing with the judge, have either one of them look at me and say, "You got to be kidding me," you know. So that was the way I was, and I won a lot of cases that I shouldn't have won, really, if the other side had just taken a more reasonable path in what they were trying to advance. Instead, they lost the whole enchilada, unfortunately, overstating their case. Now, with AI, unfortunately, it can make things sound better than they really are.
God,
So,
can it ever?
yeah. So the same thing applies. Don't fall in love with your case. I was helping a high school student with preparing for a mock trial, and that was what I had to tell her. I mean, she read the facts, and then the position that she wanted to take was more than she needed to take to win the case. So the question is, do you really want to do that and put your credibility on the line? The credibility of a lawyer in front of the court and in front of your adversary is the most important thing that you have. So you have to secure it, and you have to secure it against any idea that you're going to fall in love with your case, whether it's created by AI or just your own imagination, I guess.
Yeah, I've heard you describe credibility, in infrastructure adjacent language. It's built slowly and lost in a heartbeat, right?
Eh,
So where do you see AI-driven credibility collapse happen fastest? Is it in pleadings or discovery disputes, early hearings, negotiations? Where is that collapse actually happening?
Well, I think that it occurs anywhere in the course of the process, because you don't know where the AI is going to exaggerate and when they're not. Okay. So, and even if you're using it properly, it's sort of defaulting, trying to make things the best they can be for you when you're going through this. So you just have to guard against that all along the way, just the way it is. And just think about this. If you're early in the case, you're going to build your case depending on what those facts are that you think are uncovering and that are important. As you go on in the case, that credibility that you build by having a case that's got good infrastructure goes away the minute you overstate something. So it doesn't matter when it happens; it's just a loss that would occur. I mean, I always taught people to be honest with your client, honest with your coworkers and the people that are helping you prepare the case, honest with the opposing party, and certainly with the court, because that's an ethical obligation. But most of all,
Wait, what? No, I'm kidding.
no, be honest with yourself. Make sure that you understand how important your credibility is and what will happen if you don't maintain that credibility.
I kind of want to add in just a little thought about pro se, do a little reality check here. In your article, Judge, you noted that modern tools make concealment easy to uncover, and you also acknowledge the real world pressures around litigation behavior. If we layer in pro se parties are using AI to communicate in legal language while courts fear a flood of AI generated junk. So what's the least bad balance? Is that the best grammar there? The
Yeah.
least bad balance? Guardrails that filter nonsense without filtering, or legitimate claims?
This is a really difficult problem. And when I teach judges about AI, this is the thing that comes up the most, because when you think about it, especially in state court and, small claims and county court and the smaller circuit cases, a lot of people are representing themselves. And you have an access to justice issue. The access to justice issue is this. Sometimes somebody has a good case, but they just can't express it. So they need the AI to help them put their case together. They don't have either the ability themselves or the resources to hire somebody that can speak for them. So are we going to tell them, you can't use this because it's going to be harder for me as a judge because you're going to give me junk? Okay. So you can't, if you tell them not to use it, it's a worse problem than if you have to do more work as a judge. I mean, that's what I'm telling them. Of course, it's easy for me to say because I'm not the poor judge that gets flooded with all this information. There are remedies for pro se parties that overdo the pleading thing, and they give you a bunch of junk pleading, and that is you can limit the amount that they can submit without having an attorney. I mean, at some point you can just say, look, this isn't working because all you're giving me is junk, and so their pleadings are just not valuable. There's actual law on that. It's not AI related that judges can do that. Until you get to that point, I think being draconian about limiting the use of AI is a problem with pro se parties. But Ralph Losey may have an opinion on this.
Well, slightly different. In my lengthy career, I've been involved in many pro se cases, and more recently, I've been talking with judges on the federal bench about AI, and many of them are glad to see AI used because what was once totally incomprehensible that they or their clerks had to look at is now becoming almost makes sense, particularly in things like, the prisoners' petitions claiming all kinds of inhuman conditions. The federal courts are flooded with these, and they have to hear them. They have to look at them. And now that it's improved. So what is just totally garbage? I don't know if their success rate is improved, but at least it's easier now for judges when they've got some intelligent force here advising these prisoners, or, that's just one big example that's a problem in the federal court, always has. So the pro se problem is nothing new, and I don't think it's made it worse at all. I think it's really making it better. And I think the worst lawyers are now at least a little better than they used to be. And part of the problem is there's just too many lawyers. And so, yeah, will AI put a lot of lawyers out of work? It probably will, but there's more lawyers employed now than there ever was. It's at an all-time high level. A lot of law schools out there that are, trying to make money, and these poor kids come out with $150,000 in debt, and nobody will hire them because there just isn't a need. So part of it is the profession's own fault to just flood the market with lawyers thinking that that'll work out. It has not, will not. AI is not really putting them out of work, but I think it's having a positive impact. And I think we need to focus more on the good stuff it's doing, because it is incredible how much the writing of attorneys can improve when they use these chatbots and they use it properly. Instead of being verbose, it can be clear. It can use rhythm and rhyme so that it not rhyme, but just that it speaks well. It's easy to read. It's got insights as a copy editor that are just amazing to me. It can really help your writing improve. And that needs to be done because, only a very few lawyers come out of law school knowing how to write well. Maybe some in law review know, but so overall, I think it's doing a lot of good. And I would suggest that we're dealing here with just perennial problems that have nothing to do with AI. For instance, I think what Judge Ralph says here is about advocacy, how to, only focus on the truth. This was giving this similar lecture 5 years ago before there was AI, because lawyers need to learn this. They need to be taught properly in law school and by the senior partners, and they're not. AI is just another way of talking about it. But this professionalism, this knowing when to sit down and limiting your argument, don't argue everything, don't figure out the word limit and then write 2 words less than that, be smart about it. These are things that aren't really an AI generated problem. And the AI generation on the whole is a tremendous plus for us if you know what it's good at. And one of the things that it's great at is to help bad lawyers bad lawyer writing be good, and good lawyer writing be great.
I want to say I totally agree with it that you say about making things better, but the courts are also working on this on a committee with the National Center of State Courts for AI adoption in courts, and they're looking for ways to help pro se parties properly use AI in order to be able to get their voice in court. So there are solutions to this, and institutionally we can help with that as well. They used to have just clerks who would help people physically with things, but now they can automate a lot of this and put it through agentic AI and other benefits that would help some of these pro se parties.
Well, and beyond writing, I bet it's also a procedural boon as well, because imagine your pro se litigant receives a motion or something like that. They can ask AI, hey, I'm in such and such court. When do I have to respond to this kind of thing by under the local rules?
Absolutely. It's a big help. It's a game changer for being able to do that stuff after hours or, anytime that you have access to it and so forth. So I totally agree with that.
Now, what do you think about this idea of pro se litigants using AI or, even clients doing so within the context of an attorney client relationship in light of recent case law that suggests that putting otherwise privileged or confidential content into a public facing LLM negates that privilege, waives confidentiality protections, and potentially waives work product protections and implicates these privacy concerns? So, what's your thought about that?
Well, pro se doesn't have attorney-client privilege, really. So let's put them aside. Now, I haven't studied this case. Maybe other Ralph has, but when I looked at it and I said, this is bad facts making bad law. It's ridiculous to think you're waiving anything. Now, on the other hand, I also say, and I agree, that the rules require us to use secrecy. Rules require us to pay the minimum $20 a month if you're using ChatGPT and have the privacy
Yeah.
so it's kept confidential and that it's not used in training. But they're not understanding the facts to think anytime you use AI, you've waived anything. It's not true. It requires, and the attorney-client privilege is not a lawyer's. It is the client's privilege. The client can waive it if they want. Uh, it's common that certain things be waived all the time, like, does this lawyer represent you? Technically, that comes within something that's secret. Most clients will waive that. Yeah. I hired him. Things like that. And work product privilege is not a privilege of a client, is privilege of a lawyer. And it is triggered the minute there's anticipation of litigation. We all know that because of the notice required to preserve evidence, right? And just because you're using AI to study, nobody would have thought to do that. I'm using a computerized research to study or anything like that. So I think it'll settle itself out. And I don't like it when the media focuses on fear and the latest thing because I've seen this so many times. I've gone through so many technological revolutions in the law, and it works itself out. And I tell everybody, just calm down a little bit. Focus on the good and just quit focusing on the scare stuff. I know it sells papers, but this will work itself out. Eventually, a Judge Peck will come along and settle it with a great opinion, like the Silva Moore. This is going to work out, and it's going to be a tremendous thing for the legal profession and for all of humanity when we can harness this kind of intelligence because it can already think better than most lawyers. Not all lawyers, but it can really help. And most lawyers are going to need this kind of help because they're more focused on other things like the feeling of helping the client deal with the enormous stress of being in a dispute or the enormous stress of writing a new will or the challenges of selling your business. We're going to need human lawyers to deal with this. AI is not really that good at, but AI is a pretty good talker and thinker.
Well, I have a little bit different view about that case. I think that case right now, unfortunately, is the law in that jurisdiction. So, I think that there are issues with it. I totally agree with Ralph. I don't want to overstate anything or make it, hair on fire kind of a situation. But here's the problem. Clients are going to go on AI to try to save money. They're going to try to go on AI to do the work and then bring it to their lawyer and think that their lawyer is going to have to do less, spend less hours, therefore charge them less money. That's true for litigation. And I know it's true with my son's M&A practice too, because his clients are already doing it. The client will go on AI, work on a contract, and then bring it to him, and it usually takes more time for him to undo all of the things that the client did rather than if they had come to him to begin with. but that's what lawyers are facing now. And unfortunately, until these things shake out and we get a court that's going to look at it, that really understands about AI, decisions can go either way. And so that it may be the obligation of an attorney to say, look, before you go on AI, let's deal with this in a way that protects the privilege, so that at least the client understands that they could be waiving something by doing that. When I read the case, I said, this is stupid. I mean, the idea that a client can't do research so that they can intelligently deal with their lawyer before they talk to the lawyer by using AI, I don't think that it's good law. But unfortunately, it is law, at least in that jurisdiction. Again, we're not giving legal advice, though. So,
Yeah, we're not. I'm not even allowed to. Maybe you
yeah.
are, honorable
No, this
Ralph,
is thoughts
but
and feelings
yeah,
vibes.
but I mean, heck, I've it's so easy to distinguish on the facts. I mean, I've done that 100 times. It's not so easy to make law that sticks. We're going to see all kinds of off the wall opinions in the beginning of anything like that. I just not. It was much worse before with Google. I mean, this is nothing new. Clients have been coming in, well, I Googled this, I Googled that. Google was really dumb, and so they did a far worse job. There was no confidentiality with Googling. So it's just not understanding the basics. And overall, I think they're doing a better job. And in the old days too, yeah, I had some clients that were really smart. They were smarter than me in many regards. They could write a first draft, here's what I want to do, and I'd be blown away. Yeah, they're smart. They get it. They weren't lawyers, but just because, they're a client doesn't mean they don't have some valuable information, and they should, and they do share it with their lawyers. They always have. Going back to Lincoln's day, they would talk to the client. I mean, so this is a fundamental misunderstanding. Don't worry about it. It'll work itself out. We will be able to use AI, and it will lead to quicker work. And ultimately, there'll be fewer pro ses, because lawyers that want to specialize in the consumer, the people that need representation that could never afford it before, they'll be able to do it, and they'll come up with a system. And that's what I think a lot of people are working for, is to empower AI to be used by lawyers so they can represent more people and do it quickly. And those are the folks that I am concerned about. And, it's going to be tough for the bar to adapt to that, but I think we need to.
I know that we are coming up on the end of our time together, so I will leave it to both of you, Ralph, to decide who goes first. But if you could leave one thought that's burning in your mind, burning in your heart at the moment with our listeners, what would that be?
I'd say never let AI drive the train. You're responsible, and you have to be in charge of the facts and the representations that are going to the court. So you drive the train, and then you won't get yourself in trouble.
And Ralph Losey, what about you?
I'm always on the next thing. AI, I've been working on it now for, I don't know, 4 years, and go on old AI since 2012. The next big thing is coming, and we need to start thinking about it, and that is quantum computing. They are starting to work, and you think AI is dealing in new territory. Wait till you get into the latest in quantum mechanics. And this is not something that's far in the future. It's already here. In the course I'm working on shows it is not only the future of where the law is going to be next. There is beyond AI. It's combining AI with quantum and seeing the probabilities and understanding really what beyond a reasonable doubt means, understanding really what preponderance of the evidence means. These are all statistical thinking. And we're going to be moving into the law is going to change from straight causality, this causes that, which is physics has proven that the universe isn't built like that. It's all probability. So those of you who have loved AI and have loved eDiscovery, as I have both, there is yet another challenge in front of us. And I would encourage all of you to join with me and get on that new train and get prepared for yet the next big challenge that we're faced.
Well, it sounds like we are going to have to bring you back onto the pod to talk about that, because for one, I've read your article on quantum computing and then promptly went down a massive rabbit hole on AI, learning what it was. And now I find myself utterly fascinated. But all right, we're coming up on our time here. So I want to thank both of you for coming back on our pod. It is always a pleasure talking to both of you. You are such illuminating thought leaders in this space. And I absolutely cherish the time that we get to spend together. So thank you, thank you, thank you from the bottom of my heart for being here.
I agree. Thank you both so much. And your perspective is invaluable. Can you share with us, Ralph Losey, just a little bit of information for our listeners if they want to dive into your writings or your blogging, your educational material? How would they go about accessing that?
Two things. I mean, just go to eDiscovery Team. That's e-discoveryteam.com. And you'll see up on the top the different selections. There's 5 of them. One of them is writings, and there you'll see what I've written. I mean, I'm probably not as good at practicing law as Judge Ralph was because I've always spent a lot of time writing. I've written now over 150 articles about AI, and before that on eDiscovery, going back to 2005, even more than a lot more than that. I used to do it once a week. And so you can go there and find my writings and go through the selection. You just click on it, see what interests you, particularly if you're interested in AI. I don't try to keep up with the latest on eDiscovery, to be honest with you. I'm always kind of, now I can do just whatever I want as I'm retired. And what I really want to do is look for the next big thing because I'm really the happiest on the cutting edge. And AI is still cutting edge, but the next thing is looming forward. And like Angie, I find it fascinating, and it is a connection with science, which is what I've been about. And the last plug is I've already got the test course up, quantumlawcourse.com. So you can go there too and see the sneak previews, but not the course yet, almost.
And Honorable Ralph, if we want to find your writings, where can we do that?
Well, you can either go to Ralph Artigliere on JD Supra or Ralph Artigliere on EDRM. I mean, just put them in Google and it'll come up with a list of my stuff. You can go on EDRM or JD Supra, and it has the latest stuff I've written. I've got an article coming out in the Journal of Law and Technology, University of Florida. That'll be coming out this spring about the gap of knowledge between the attorneys who practice in the eDiscovery area and then everybody else, and how that's going to fare with AI, which is going to be, I mean, it's coming at us, it came at us so much more quickly that this gap is extremely important. Actually, Ralph Losey and I wrote an article on a Journal of Law and Technology not too long ago. I'm sure that's on his list of writings somewhere. So
it is. I'm proud to say I got to write with the Honorable Ralph. It was terrific.
And it's always a delight to be on with Bree and Angie because they just bring so much good knowledge through such an accessible way, don't they, Ralph?
They do, and thanks for inviting us. And I'm encouraging them. They need to change their show to video because we get to watch them, Ralph and I, and they are magnetic personalities, delight to listen to, and they're also a delight to watch on the full spectrum with eyes too. And we hope to see that coming your way soon, Angie and Bree. And thanks again.
Okay, we got the hint, didn't we?
All right. We'll get an intern. All right. Well, that is all the time we have today, folks. Again, Ralph Losey, Honorable Ralph Artigliere, thank you so much for being with us today and sharing your wisdom with our listeners. And to our listeners, thank you so much for joining us on eDiscovery Chicks. We hope you learned something new, felt empowered, or just had some fun along the way. Join the flock by following us on LinkedIn and Instagram, and check out our website, eDiscoveryChicks.com. If you loved this episode, share it with your network, leave us a review, or tag us on your socials. And don't forget to subscribe wherever you get your podcasts so you never miss an episode. Bye.
Bye.